You are listening to the NPZ Law Firm Show. Immigration woes, visa serve nos. US and Canadian immigration and nationality lawyers who speak your language.
Back on the Immigration Hour with the NPZ Law Group, simplifying immigration for you. I'm Vijaya talking to the NPZ Power Team of Lawyers. Ludka Simovchek is NPZ Law's partner and managing attorney. Hi, Ludka.
Hi, Vijaya.
Welcome. And, Ludka, when an F-1 visa student violates the status, is there any recourse to really get that status back? And a follow-up or rather a preemption to that question is what really is a violation of status when an F-1 student is concerned?
That's a good question. So just imagine we have about 1 million F-1 students in the United States. So of course it happens. Sometimes it's the fault of the school, negligence. Sometimes it is the student. They are sick. They stopped going to school. There are different things for violations. But, the key with the F-1 to maintain their SEVIS record and maintain their F-1. Otherwise, they're going to get in trouble. So there are two ways to regain the status. So once they violate the status, number one, there is filing reinstatement application within the United States. And a second way is depart the United States and re-enter, assuming they already have F-1 visa. So let's just talk about the reinstatement for now. So if the student does not want to travel and student wants to deal with it in the United States, that would be filing a reinstatement application with U.S. Citizenship and Immigration Services. There are certain eligibilities that we would have to look into, of course, before filing. So for example, the student should not be out of status for more than 5 months. If it is more than 5 months, then we would have to show exceptional circumstances that prevented the student from filing the reinstatement application on time. But even within the 5 months, it's important to explain what the issue was, why they fell out of status. Maybe there was a natural disaster or some type of sickness, depression, different things. And sometimes, as I said, it's negligence of the school. Second, we have to show that there was no unauthorized employment. We need to show that there is no other grounds of deportability, so they have no other issues such as criminal, fraud issue, and so on. We need to show that they are pursuing full course of study as well. There is no repeated immigration violation. So if you have a student who repeatedly violates the status, they're probably not going to get their status reinstated. So that's important as well. Once we meet all of these criteria, the students should consult the case, of course, with International Student Officer because they have to recommend it and they have to issue a new I-20 for reinstatement before the filing. And then the student can file Form I-535, as I said, with USCIS. So this is within the United States. Pay the fee, submit supporting documents. As we discussed, the reason. If it's a medical reason, they have to submit medical records and so on. The only downside of this type of application is the timing. This could take 6 to 12 months.
Wow.
So that's, if student is looking for a quick fix, that's going to be a problem because it's taking too long. They are talking possibly about expedite processing, premium processing for additional fee, but it's not happening right now. Let's talk about second option. Second option for students who already have the visa is depart the United States, of course, get the new I-20 from the International Student Advisor and re-enter. That's pretty quick solution. So if somebody is looking for a quick fix, that probably would be the best option because otherwise they would have to wait for 6 to 12 months. But of course, the question I get from students is what is better? What's easier? And there is just no right answer because it depends on the student. We have students that absolutely don't want to leave. They're worried. But there are risks for both options. And I think very important is for the student to understand both options and decide what works best for that particular student. As I said, for some, maybe just traveling, but with the COVID restrictions, that's not easy either. So that may be a problem as well. So I would say for us, 50% decide to do reinstatement, 50% decide to travel and re-enter. Of course, I would recommend to all F1 students to try to maintain the status and be very vigilant and not to violate it. But in case it happens, it's important for them to know that there is a fix or solution possible.
Yeah, to know that is a great peace of mind right there. So whether you're a student or anybody else who's stuck at the crossroads in US and Canadian immigration law maze, worry no more, because NPZ Law Group is there to help you and handhold you through it all. Get the help you need today. Visit visaserve.com or call them at 201-670-0006. And when you mention Mirchi, you get a special discount off your consult. More very relevant and key pointers on the immigration law with the NPZ Law Group attorneys coming up in just a bit.